Okay, so this is Warren Redlich of West Boca News, and as people know, I'm a realtor, and I'm here with Ron Kaniuk. Am I pronouncing it right?
You're pronouncing it right, Ron Kaniuk.
Kaniuk, okay. So Ron is a member of the West Boca Chamber, and he's handled many cases dealing with West Boca residents. And I wanted to talk to Ron today and ask him about his experience with residential real estate and what kind of problems you might have seen in real estate transactions in the past. Can you think of anything that stands out where you've seen a transaction have trouble? What kind of things happen?
Well, the big problem that I've seen over time, and it's less so now, but still has the risk, is the foreclosure crisis, making sales difficult, just in terms of either short sales or regular transactions where people wanted to get out before a foreclosure was completed, because people could be, either have no equity or have equity in the house and still be having trouble paying their mortgage, want to sell the house. You've got to deal with the foreclosure in some context and resolve those issues before you close. And then the other issues that I see are just from the beginning of the transaction till the closing, the potholes that come up in any real estate deal, whether it's problems with the contract, problems with the walkthrough, problems with financing, sellers and buyers miscommunicating, issues regarding what personal property is being left in the property, what's being sold as part of the closing, what's being sold separately. All those sort of issues are issues that can muck up a closing and make it difficult to complete what is a big, financial purchase and a monumental transaction in somebody's life.
Let's try to walk that through. So first of all, you typically get hired around the time the person is making an offer or after they've made an offer. And do you typically represent both buyers and sellers?
I represent buyers and sellers, not at the same time, obviously. Right. And hopefully I'm retained at the part of the process where they're either making an offer and getting it put to paper and signed, or in that review period where I can review a contract and make sure that issues are addressed and taken care of, so there are no open questions or open areas that somebody could dispute and argue that there wasn't a contract in the first place.
Is there typically a window, somebody signs a contract to buy or sell real estate, and there's a window where they have a few days to check with an attorney?
Generally, you have a couple of days to consult with an attorney, and I like to hopefully be involved before that process begins or as soon thereafter as you can, to be able to walk through and start hand-holding on the deal and make sure that deadlines are met. If I'm representing the buyer, then I need to make sure that they conduct the inspection in the proper time frame, that they apply for their financing within the specified time frame, so that if there are problems with the inspection or with the financing, that they've done what they need to do to be able to get out of the deal if it goes bad. If I'm representing the seller, I want to be able to mark those deadlines on a clock and know that the buyer is doing what they need to do, so that I could be aware if there's a problem and see if there's going to be a hiccup. And I also want to be involved in terms of getting the title documentation ready, so that when the time comes to close, the seller's able to provide adequate title and convey the property free and clear of any liens and encumbrances.
Okay, and that's lawyer speak.
That's lawyer speak. I apologize.
But when somebody sells a house, there's a registry in the state or the county that says who owns the house.
It's who owns the house, who has a mortgage on the house, what taxes are due, what the taxing authorities are, if there are any liens. Those liens could be from municipalities, or they could be from private individuals.
Or contractors.
I have a client that I'm representing on a variety of matters related to some of his financial distress issues. He's got a pending bankruptcy from New Jersey that was filed a number of years ago, and we're trying to resolve some issues with his house down here. We got a letter the other day from a private investor seeking to see if he was interested in selling, and it was a unique situation because the letter referenced a lien that had been filed within the last month and a case number that was for 3 years ago. And when I went online to search, I was having some trouble finding the lien. and the case number didn't match anything with regard to my client. And when I was able to do a little more digging, what I discovered was that while the lien was correct, the lien was a very recent lien in the last month filed by his air conditioner contractor. It was for $2,400, and as I said to my client, pay the lien and it'll be resolved, and that will be it. The 2013 case that was referenced in this letter was not a foreclosure case down here, but it was the bankruptcy case in New Jersey with a lis pendens that had been filed by the trustee that we knew about. So, but it was finding those things and looking for those documents and understanding what it was. We would not, whether he was selling this house now or whether he was looking to refinance the house now, we would need to resolve all those title issues relating to who had a mortgage, who had liens, what taxes were owed before we could go forward with any transaction.
So there are cases, there are some transactions where it may be less important. You have a simple transaction, you don't have any liens, you don't have any problems in your house, you might need an attorney less. If you've got a bankruptcy in your past, you know you've got some business disputes going on, it might be more important to hire a lawyer in that situation.
I think it's absolutely important. I like to be involved in any transaction. I think it's important to have a lawyer at the table. What people don't understand about real estate transactions is that down here in Florida, while there's a title agent who will handle the closing, that title agent doesn't represent either side. They're representing, just facilitating the transaction, getting the documents together, making sure that the old bank gets paid off and that a new bank that might be making a loan provides the funding and gets their mortgage recorded, and that all the other documents are signed and executed by the proper parties, and they're not representing the buyer or the seller or facilitating their needs and goals. And so even in the simplest transaction, there's always something that usually needs to get done. The more complicated the transaction is, the more moving pieces that there are. If somebody has a significant amount of artwork or furnishings that they're selling as part of the transaction, they're going to need a separate contract for that. They're going to need a separate bill of sale. They're going to need other ancillary documents to help facilitate the transaction. So the more complex it is, definitely the more need for a lawyer there is. But what my experience has been is that 9 times out of 10, there's always a need for an attorney to do something in a real estate transaction, and the sooner that an attorney is engaged and involved, the easier it is to avoid more pitfalls at the end.
Okay. So one of the things that comes to my mind, I'm learning the real estate game. I started learning the real estate game a few years ago, the Florida real estate game, I should say. And there's these two contracts. There's what's known as the FAR bar, and there's the FAR bar as is. And I think when you come into it the first time, it seems like the FAR bar is the standard contract, and the FAR bar as is an optional contract, but it seems like most people like using the as is contract. Can you explain a little bit about what maybe you disagree, but can you explain a little bit what the two contracts are and why one's better than the other?
Yeah, I don't necessarily think that people use the as is more than the standard FAR bar. But the difference is that an as-is contract is exactly that. You're buying the property as is. It limits your inspection rights. It limits your ability to get out of the deal if you discover something later. We all walk through, when we're looking at homes, you walk through homes for walkthroughs to look at a house to buy it at its best. The owners have cleaned it up. The owners have hopefully gotten rid of whatever extra stuff they're hoarding and keeping. The walls are painted. The house is cleaned and looks spotless. After you sign the contract and you hire inspectors to look at the house a little more closely, you sometimes discover that it's not as pretty a picture as the seller's agent and the seller would make it seem. You look at the roof and see if it needs, repairs. You look at the walls. You look at the appliances, and suddenly you could have a house that was in your price range, and suddenly when you add in the repairs that might need to be done, not only is it out of your price range, But generally, you're not going to have the fund if you're relying on financing from a bank. The financing is not going to include repairs. The financing is just going to be based on the value of the property. You're going to have to come out of pocket for repairs, and if you're on a tight budget, it's going to make it more difficult to afford that transaction. The as-is contract limits your ability to either negotiate to get a discount from the seller on the purchase price or a credit at closing to be able to allow you to make those repairs, or to even scrap the deal in its entirety and say, this isn't the house we expected to be buying because we didn't expect to have to pay these extra things to repair it. We're going to walk away.
Or put it another way, the way I see it, the as-is contract is an easy way out for the buyer who decides he doesn't want the house. He's got, let's say, 10 or 15 days to get an inspection. Maybe it's a shorter window, but he's got a period of time where he can have an inspector come in, and it doesn't matter what the inspector says. Before that inspection period is up, before there's a period of time, the buyer can say, I changed my mind, I want out. Or the inspection said this, I want out. The other side of that is, if they still want the house, they can use that inspection to say, listen, I want these things done, or else I'm getting out.
Right.
So that's one side of it. So on the buyer side, it's hard to see a downside for a buyer to use the as-is unless they really, really want the house and there's some... And I think with the FAR bar, there can be provisions that the seller's going to have to pay for certain things. The standard FAR bar contract.
Correct, yes.
So, if I really want the house and there's something wrong, the seller has to pay up to a certain amount to fix certain things. So the other side of that is the seller side. And the seller side, you can tell me what you think about this. If I'm a seller and I know my house has problems, and I don't want to pay for them, then I like the as-is because the buyer either decides he's going to take it or not. And if they walk away, okay, I'm not out of pocket. If I do the FAR bar and they want me to fix stuff and I got to pay for it, all of a sudden, maybe that's not what I wanted. But if I'm a seller with a pristine house, I know my house is in fantastic shape, I know there's not going to be a problem, I don't want my house off the market for 15 days while this guy makes his mind up whether he even wants to buy my house. So, from my perspective, if I'm a seller of a really nice house in great condition, I don't like the as-is contract. And I might insist, or if I'm choosing between two offers, I might take the one that's not an as-is offer. Does that make sense?
No, I agree with you on that.
Yeah.
And that's a good analysis.
Because I talked to people who said as-is always better, and I don't agree with that.
No, and for a homeowner, when you're selling the house, you don't want it off the market until you've really, got a firm contract and know you're going forward. The longer there's that limbo period, the more difficult it is for you.
So I emailed you earlier today or yesterday about this case that came out of California. And I got it from the Florida Realtors Association saying this was an interesting case, and there's this question about the role of the real estate agent or the broker representing the buyer, not taking attorneys out of it for a minute, because this case did not involve attorneys in the transaction until it was too late.
Right.
So the short story is some buyer, they said it was from Hong Kong, but he had a Japanese name, so I didn't figure that out, was buying a house without having seen it, relying on an agent, and was told it was 15,000 square feet, and it turned out it was 10. And his agent didn't know it, and the seller, I think, failed to disclose it properly, what the square footage was, so then it ends up being this big lawsuit from the buyer suing, I think, the seller's brokerage, right?
Well, the interesting was they worked at the same brokerage agency, if I read it correctly.
Right.
So that was the complicating factor as well, is that you've got agents who have duties to their respective clients who work under the same agency umbrella and therefore have a multitude of obligations to each other to disclose different things.
Right. But there's conflicts of interest in a sense, because you're
Correct.
representing both sides. Essentially, the broker is representing both sides in the transaction.
The ultimate broker is. The agents aren't, but the broker is going to get pieces of both parts of the fees.
So in Florida, we have sort of the default for a real estate agent relationship with the client is what's called transaction broker. And there's another form of relationship called single agent. And maybe, are you comfortable explaining that, or you want me to try to take it?
Ask me what...
So a transaction broker has not a whole lot of obligations to his customer. I wouldn't even call it a client. It's like you have to be honest, okay, and you have to get the numbers right. But outside of that, maybe one or two other things, you don't really have any obligations to your customer. It's really more the transaction broker represents the transaction. And a transaction broker can bring in a buyer and represent both sides. One agent can represent both buyer and seller at the same time, and then there's no there's no duty of loyalty in particular. There's another type of relationship that is the second most common in Florida called single agent. And a single agent represents, let's say, a seller, and they have a duty of loyalty to that seller. They can't bring in another buyer on their own as a single agent because they can't be loyal to both sides. And they can't even represent the buyer as a transaction broker while still representing the seller as a single agent. There's a process where they go to the seller and say, hey, I've got a buyer, you need to release me from my single agent status and let me be a transaction broker for you so I can bring this guy in.
And you've described that well. That was exactly.
And that creates this, again, who's loyal to you? You're the real estate customer. You're selling your house, you're buying a house. Who's the person involved in this transaction who's loyal to you? And one of the things that I see is, well, this is why you want an attorney. Because the attorney is loyal to you. And, of course, I pitch myself as I'm a realtor and an attorney. There's some complications there. I actually think even if I'm representing somebody, it's not a bad idea for them to have their own attorney too. I'm not suggesting it's necessary, but that can help. Do you see that? I mean, is it something that comes up, or you haven't really seen it? The conflict?
I haven't seen it. The conflict is there. Mm-hmm. And the real issue, and it's not so much one that I get involved with, but when you've got one real estate agent working both sides of the deal, their goal at the end of the day is to maximize the sale price.
Right.
And that serves the seller, and it also serves them,
right,
because it increases their commission. So when you're the buyer, you're essentially sometimes negotiating against yourself, because you don't necessarily know whether there are other offers, or whether the offers are really better than yours, or whether you're going a little higher than you need to get that purchase done. I get involved 99.9% of the time after that process. And even if I was involved a little before, I'm rarely involved in those sort of issues. I describe those issues as business terms, whether it's in the context of a real estate deal or the context of a business deal that I'm doing. If my client is comfortable paying a certain amount for a house or for a product, I'm not going to get involved in the merits of that. I don't have the expertise.
Right.
But the problem is that when you have one realtor doing both sides of that, you don't have anybody saying, you know what, this is really too high, or you don't need to go that high, or you don't need to do that. Whereas if you have somebody representing you as the seller separately, maybe they're able to read the situation. They're not going to get explicit, details from the seller's agent anyway, but maybe they're able to read the tea leaves. Maybe they're able to do an analysis of the market and what sales prices have been, or what the square footage price should be, so that you can, estimate what the offer should be at its high end.
So
that's really my analysis of it.